The following news flash is brought to you by the Lone Star Lowdown. Markets for Friday the 17th of June, 2016 are currently trading with gold at $1,290.58 an ounce, silver $17.39 an ounce, Texas crude $46.21 a barrel, and Bitcoin is still on the rise at 751 U.S. currency. Today in history, the year 1885, the Statue of Liberty arrives in New York City aboard the French ship Les Airs. It was designed by a French Freemason sculptor, Frederic Auguste Bartholdi, and built by another French Freemason, Gustave Eiffel, famous for building the Eiffel Tower. Though the Statue of Liberty wasn't completed and dedicated until October 28, 1886, it first arrived to America from France. Today in history. In recent news, the United States is set to keep their destroyer, the USS Porter, in the Black Sea in spite of Russia warning that the U.S. patrolling there undermines their regional security. Establishing its presence for over a month now, this initiative from the U.S. falls within a greater push for NATO to have a presence in the Black Sea in expectation of the NATO summit in Warsaw next month. If you recall, the presence of U.S. warships in the Baltic Sea caused a near flyby by Russian fighter jets, in which Secretary of State John Kerry said that the U.S. would have been within its rules of engagement in shooting them down. Navy Secretary Ray Mabus aboard the USS Mason, another U.S. destroyer in the Mediterranean, told Reuters on Thursday that, quote, "We're going to be there. Speaking of the Black Sea, we're going to deter. That's the main reason we're there, to deter potential aggression." However, he did admit that, quote, "If a decision is made to create a permanent force, of course, it would destabilize because that is not a native sea." Increasing tension between the two superpowers, the U.S. Navy deployed 2 aircraft carriers in the Mediterranean ahead of the NATO summit as Washington seeks to balance an increase in Russian military activities, also in the Mediterranean. A Texas state lawsuit accusing the State Department and other federal agencies of violating the Refugee Act of 1980 for failing to consult with state officials before resettling Syrian refugees within the state has been dismissed by a judge in Dallas. The lawsuit also charged that the nonprofit relief group, the International Rescue Committee, had breached its contract with the state of Texas. In his opinion released yesterday, Judge David Goodbay of a federal district court ruled that Texas's accusations had no legal merit. However, he didn't rule on whether the federal officials had violated the Refugee Act. Texas Attorney General Ken Paxton stated in response that, quote, "I am disappointed with the court's determination that Texas cannot hold the federal government accountable to consult with us before resettling refugees here. We are considering our options moving forward to guarantee the safety of Texans from domestic and foreign threats." Lieutenant Governor Dan Patrick said in a statement that Texas has the right to know who the federal government is bringing to Texas, where they are being placed, and what they are doing to guarantee the safety of all Texans. This is Rick Rohde with your lowdown for June 17th, 2016.
You gonna do? Yeah. Bad boys, what you gonna do? What you gonna do when they come for you? Bad boys, what you gonna do? What you gonna do when they come for you? When you were 8 and you had bad traits, you go to school and learn the golden rule. So why are you acting like a bloody fool? If you get hot, then you must get cool. Bad boys, what you gonna do? What you gonna do when they come for you? Bad boys, what you gonna do? What you gonna do when they come for you? You chuck it on that one, you chuck it on this one, you chuck it on your mother and you chuck it on your father, you chuck it on your brother and you chuck it on your sister, you chuck it on that one and you chuck it on me. Bad boys, what you gonna do? What you gonna do when they come for you? Bad boys, what you gonna do? What you gonna do when they come for you? Bad boys, what you gonna do? What you gonna do when they come for you? Bad boys, what you gonna do? What you gonna do when they come for you? Nobody now give you no break. Police now give you no break. That old soldier man I give you no break. Not even your agent now give you no breaks. Well, hey, bad boys, what you gonna do? What you gonna do when they come for you? Bad boys, what you gonna do? What you gonna do when they come for you? Bad boys, what you gonna do? What you gonna do when they come for you? Bad boys, what you gonna do? What you gonna do when they come for you? Some
cause people to want to avoid these systems at all costs. That's part of the reason our public officials in the criminal justice system has been able to achieve a 99.6% conviction rate. Everybody takes the deal because the system has been designed to force you into a position where a reasonable person of ordinary prudence has no reasonable option other than to take the deal. And civil is not much better. We expect these judges to be fair and just. And that is just absolutely wrong-headed. From the very beginning, our expectations are just simply wrong. And last week, I started out talking about some of the common fallacies. And I won't go into those this week. I may do that again in another week or so. But here I'm going to talk about stuff they don't teach in law school or in high school civics class. And to start with, if you're going to have a chance in court, you're going to need to understand how the courts really work and develop some methodologies that will allow you to maneuver through their complex system. Well, the court system is complex. It's not beyond understanding because it is consistent. And last week when I talked about going to court and expecting the judge to be fair, do not expect the judge to be fair. Do not expect the judge to be just. We don't want our judges being fair and just because that implies that they get to juxtapose their concept of fairness and justice on the rule of law. I want that judge determining the facts in accordance with the rules of evidence and applying the law as it comes to him to the facts in the case. I am not interested in his personal perception of justice. That's what we had in the common law. And this country fixed that. There's no more of that common law nonsense where a judge can rule any way he wants to. We wanted him bound by statute. It is not the judge who is there to bring justice. It is the legislature. It's their job to so design the laws so that they result in the just adjudication of cases. So I want that judge to follow law, and I don't care what his opinion is about it. Well, that's a primary fallacy. And once we understand that part, then we go back and look at how the system is really, how it actually works. The system was not, from the judge's perspective, is not intended to be just, but it's intended to be consistent. And in the overall scheme of things, consistency is what we need. Now, if the law brings an inconsistent or unjust outcome, then we need to go to our legislators and have them change the law to fix whatever problem it has, and then we have our judges enforce the law the way we enacted it. Okay, in the real world, though, lawyers and judges do whatever they want unless they're called on their behavior. Lawyers and judges, they pretty well control their system. I mean, if you're a mechanic and somebody brings you a car and you get somebody like me that thinks he knows something, then you got that guy coming out there telling you what you should do when you know what you should do. You want to say, go away, leave me alone, let me do my job. Lawyers and judges, when they deal with their clients, they want you to leave them alone, let them do their job. And that would be okay if we had adequate checks and balances, but we don't. It would be okay if we didn't have so many lawyers that lawyers are put in a position where they have to create litigation when it's not necessary because they need work. We're graduating 40,000 lawyers a year. The United States has more lawyers per capita than any other country in the world. That's part of the reason we have a 99.6% conviction rate and why this country is the most litigious country in the world by far. We as potential pro se litigants, or even as litigants with a lawyer, we need to understand these facts about how the system really works. So this is the primary position to come to the courts from, is that the courts are not there to serve your interest. They're there to serve the interests of the judges and the lawyers. Now we get the part, this kind of goes to what they don't teach you in law school. When lawyers go to law school, it's Generally, it costs. I've talked to lawyers. It costs between $150,000 and $200,000 to get a law degree, and a good portion of these lawyers will have $150,000, $180,000 student loan to pay off. They got to get here and make some money. Now, they go to law school. I'm sure that they went to law school because they wanted to be like Perry Mason. They wanted to be able to help people find justice. But when they get out in the real world, they find they got to make money. And the profession of lawyer is a profession. It's their job, and they need to get paid for their job. So they're not going to do anything to jeopardize their ability to make money. And that certainly includes not doing anything to annoy that judge. Okay, the whole system is about money. The lawyer very quickly learns that he is a salesman. First and foremost, he's got to bring in clients. And the unfortunate part about that, there are so many lawyers, and they're struggling so hard to get clients. They spend most of their time trying to get clients and a very small amount of their time adjudicating cases. What they wind up doing is specializing in very finely honed areas of law. So in this area of law, they have all the motions and pleadings that they use in these cases. They've already got them in their files. So almost anything that normally comes up in the adjudication of your case, they've already got their motions in there and their pleadings and their responses to the other motions, because the other guy's going to file the same thing all the time. They're going to file the same responses back and forth. And this is what winds up happening. And it's worse. The very worst place is family law. And it's a good example. You got two people that are very angry at each other, and they go see a lawyer. And the first thing the lawyer wants is a retainer. Now, that's what he really wants. He gets that retainer, and he's got these standard little things he does and to use up your retainer. And in family law, they get past the retainer. Generally, you get a lawyer, and you tell him about your case, and he tells you, oh, yeah, you got all these claims. You can do this, that, and the other. You give him your retainer. When he uses up your retainer, then he comes to you and he tells you the real deal. Then, for the most part, he wants to get rid of you, and I'll explain why when we come back. Randy Kelton, Vet Pack, Rule of Law Radio. Our call-in number, 512-646-1984. I'm opening up the phone lines. We'll keep them open all night, so give us a call, question, or comment. We'll be right back.
You are listening to the Logos Radio Network, LogosRadioNetwork.com.
Okay,
Welcome to Rule.
Go ahead.
How dare you cut me off? Oh, I see how you are. Welcome to Rule of Law Radio. You're listening to Randy Kelton, Vet Pack. Randy, go right ahead. Tell them what's going on tonight.
Okay, tonight we have Ron Avery. Ron has sued. Oh, what's the company? Go ahead, Ron. Bail me out of this. I've got it in my notes.
What are you saying? Did you want him to talk about the lawsuit? Is that what it? Yes.
So I forgot to do part of the intro. This is Friday, June the 17th. We apologize for the first segment. We had a little technical difficulty and ran the archive for the first segment, but we're back live on the 17th day of June, 2016, and we have our special guest, Ron Avery, who we've had before. Okay, Ron, you were defamed and disparaged and sued the guy from Houston. What was the company you sued?
I didn't quite understand that. I've been defamed, but I didn't get the rest of it. What did you say?
I said, and you filed suit for, was it slander or libel or both?
I got the file suit for, but I didn't get the rest of it. What was that?
Just start in. Ignore me.
Okay. Yeah, the reason we're having this show, I presume, is because of the relationship between the news media, the so-called news media, and their ability to defame people and create whatever they want to out of them, and its relationship to this war on terror that's going on. And the foundation of this war on terror is based on 9/11 and the so-called 9/11 terror attack. on America at the World Trade Center and the Pentagon. And the apparently and obviously the government is covering this stuff up, along with the news media, the so-called news media, the mass media. They are not reporting on what the evidence that is surfaced in the last 15 years, and especially about nanothermite being found in the World Trade Center. And at the same time, they are pushing this agenda, this terror agenda, which is their foundation and justification for a police state. And they are trying to show that these terrorists are everywhere. They're in our country and they're doing things. And obviously, this last one here in Orlando, it's just amazing how quickly we find out that that's a total sham as well. And they're covering that one up, too. It's just that they're doing these things right and left, and there's no real investigation of them. The facts get covered up or not even mentioned. The only time you can really get the real facts is on YouTube or in the internet, where you find out what's really going on. It's an amazing thing. It's like the internet is reality, and the mass media is fairyland. It looks like, you think it ought to be the other way around, maybe, and they pretend that is the other way around, but it's mass media is fairyland and internet is reality. Well, anyway, and thank you for having me on again, Randy, but the reason this lawsuit is important is because it relates to the news media trying to demonize innocent citizens, turning them into terrorists in the minds of their readers. So the Houston Chronicle put a front page story out on the Memorial weekend of 9/11, implying that I was part of the far right terrorist threat, the growing far right terrorist threat, and along with the Republic of Texas and this group that calls themselves the government of the true Republic of Texas. So that's what this is about. The show I would like to do is about, and I filed a suit and it was dismissed. I filed the Houston Chronicle actually produced a web article and then a newspaper article, front page story on this and me, showing pictures of me and using my name. And I'm not a member, actually. I'm not a member of the Republic of Texas, but they said I was. And they said I was part of all this mess. But anyway, which in reality wasn't happening at all. But so I sued them, and they filed a motion to dismiss under the Texas Citizen Participation Act, Texas Citizen Participation Act, which was passed in 2011. It's a new legislation, basically. And it's just a fast track. It's even worse than a fast track. It's a short circuit of justice. And it is in favor of news media. It's in favor of reporters. And it's really to protect citizens. At least that's what it appears on the face of the act, is to protect citizens when they are participating in public affairs. But it's turned it around to really benefit news media when it slaughters somebody and they get sued for it. That these news media places use this act to get out from having a full discovery period. They just skip the discovery period of the suit and then just try to get out of it ahead of time. And so they actually won their motion to dismiss, and I had to appeal it to the Fourth Court of Appeals. And I filed my first brief, and the Houston Chronicle and the Hearst Communications Incorporated, the owner of the Houston Chronicle, filed their appellee brief. And I've just now finished filing my appellant's reply brief. So I have two briefs up there, and they have one brief. And we're waiting for them to file a reply brief, and then we will have a hearing. Well, I don't know. Hopefully they'd let me have a oral argument, but that's pretty rare that's granted to some to any appellants or appellees. So likely we won't have. I'd like to have one. I'd really like to have an oral argument, but I doubt that they're going to give me one. So it won't be long till we really know what the appellate court is going to do. If I lose at the appellate level, I will probably have to appeal it to the Supreme Court of Texas because the appellees they also appealed, so they're cross appellants, and I'm a cross appellee. They appealed the fact that the judge at the trial court scratched out and denied attorney's fees for them on the motion to dismiss. And in this Texas Citizen Participation Act, attorney's fees are mandatory. Costs and expenses are mandatory on a motion to dismiss if it's granted. And so I'm actually using that fact that the judge granted the motion to dismiss but denied the attorney's fees. I'm using that as evidence that the judge really didn't study into this thing at all. In fact, he didn't even bother to go read the statute, the Texas Citizen Participation Act, because he would have known immediately, and that's a really simple thing. Ron, I'm going to have to put you on hold. We're going to have to cut to break really quick, but we will be right back. This is Randy Kelton, Vet Pack with Rule of Law Radio. Call us at 512-646-1984, and we'll be right back.
What's a birthday party without balloons and whistles? A European birthday party, that's what. I'm Dr. Catherine Albrecht, and I'll tell you how the EU's uptight regulators are putting an end to childhood fun next.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This public service announcement is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
Talk about a party pooper. In the name of child safety, the European Union has made it a crime for kids to use party whistles, blow up balloons, and catch magnetic fish at parties. And the fear-mongering doesn't stop there. EU bureaucrats say toy noisemakers with long paper tongues are dangerous. They've banned all teddy bears unless they're washable, and they're controlling the sounds made by rattles and toy instruments. Next thing you know, European kids will be celebrating their birthdays in padded cells, for their own protection, of course. But these rules aren't so surprising if you think about it. After all, we know how much those regulators hate whistleblowers. I'm Dr. Catherine Albrecht. More news and information at CatherineAlbrecht.com.
You're listening to the Logos Radio Network at LogosRadioNetwork.com.
Yeah, I got a warrant, and I'm going to serve them to the head government, them, prosecute them. Okay. Oh, sir. Citizens arrest for Mr. Bush. Citizens arrest for Dick Cheney. Well, I need a prosecutor to come and help me. Prosecute them wicked leader, yeah, you see. Them a murderer, liar, them tell we. Them a liar, not tell sweet stories. Me not believe me, say what them tell we. 3% of America vote for Bushy. So how the hell he get the presidency? That's why me have a warrant for he. Everybody listen carefully. Listen to the words of the three shoes passy. Citizens arrest for Mr. Bushy. For warrant for Dick Cheney. Citizens arrest Mr. Bushy. For warrant for Dick Cheney. Well, we not forget Rumsfeld, warrant for him. All Dick Cheney, warrants for him. Right about the citizens in the country. Them getting some mad and them getting angry. We have some warrant we need to solve. Need a prosecutor to come and help we. Prosecutor from any state will do. Come over and let me show them too. Hear them thing yeah, when me I tell you. Three shoes, passes the truth, that is true. Hey, Silverstein, you do. You get a citizen's arrest too. Silverstein and Hamilton clean. You know them and then and them not clean. Everybody bring them in, so we could solve them with warranted.
We are back. This is Rule of Law Radio. It is June 17th, 8:35 p.m. We have Ron Avery on the line. And before we get started with with Ron, I just want to let everybody know that when we have a guest on, we are going to have those phones shut down. So don't call in just yet. I will announce a little bit later on after Ron leaves us for the night that we have turned those phones back on again. All right, Randy, go right ahead. Did you have a question for Ron, or we need to go ahead and bring Ron back up because I cut him off?
Yeah, let's bring Ron back up. Go ahead, Ron.
Yes. Well, anyway, like I say, thanks for having me on, and I just wanted to talk about what the so-called news media and mass media is doing in concert with this so-called war on terror, and which is, in my mind, has become pretty obvious and evident, and to a lot of other people, that this is just an agenda. This whole thing is an agenda that's being used by our own government in concert with these this mass media. And so I think it's really important to make the connection between the ability of the news media to libel people and to create even terrorists out of innocent parties and connect them with their own involvement in these acts, like this Orlando thing. I was sitting here writing my brief, and I was responding to the appellees or the defendants in the appeals court were saying that these things they said about me were true, and then they made it a wild assertion that now let me see if I can even find it. I think where was that? Now I forgot my train of thought on that thing. There's so much of this stuff.
Ron, my mother tells me that losing track and forgetting stuff, it's not going to get better.
Oh, yeah, right. But anyway, it's just important that and how they can get away, the newspaper thinks they can get away with saying all these things about people and then just walk away from it and pretend that, well, what we said was kind of true, and so that's okay, and walk away from it and get away with it. Because certainly I'm no terrorist, but they've linked me up with this far-right terrorist threat, which I also believe is mostly hooey. And then you see all these stepped-up things going on, like the Orlando deal, and that's pretty obvious now that is a total hoax. The so-called shooter used to work for Wackenhut, one of these security companies, and he probably has lots of friends in this private security bunch. And I mean, and then it turns out that he's been interviewed by the FBI before and investigated by the FBI. And then these reports have come out that most every terrorist event of any magnitude or size at all have had the FBI involved in it, either with informants or sting operation or some kind of involvement. And I mean, that's just how much of this are people going to put up with? This phony terrorism that has the government all intertwined with it, and then the so-called news media, mass media, won't report on this stuff. They won't report on the true facts. So anyway, in my brief, the appellees or the defendants said that some of the comments that appeared on the blog under their internet story about me and the Republic of Texas, and of course the readers made the connection that they were trying to obtain, which was to imply that we were part of the far right growing terror threat in America, which this article in the New York Times claimed is now worse than Muslim terror. And I responded to that. I went, okay, so they said that these people that wrote the blogs down beneath it were actually getting these ideas from somewhere else, not the story they just read. And I think that's ludicrous because they were kind of implying that these stories are that the responders to the article were just writing randomly at any place on the internet, and they just happened to pick this spot and write all this, which is absurd because all the comments don't even make sense unless you have the article up above it to make sense out of it. And then, but I did agree with them to a point. I said, well, yeah, some of the hatred that was expressed came from other sources, but other mass media sources, like yourselves, from other stories and many other mass media outlets, which are filled, again, with falsehoods and propaganda. And so that too. So essentially, they're responsible for that too. And I said the reason I know that, the reason why I can say that, is because Hearst Communications and none of the big news media has ever written a story on the earth-shattering discovery of super nanothermite in all the dust samples of the World Trade Center. That is absolutely earth-shaking information. And they've never covered it, not one word. And that's insane. I mean, and then they run around and pretend they have experts and they're analyzing these terrorist crimes. That's an absolute joke. And I mean, they should be laughed off the air. They should be drug off the air and horsewhipped. I mean, that is absurd. And that's why we can say that there's definitely a conspiracy between the government and the news media,
okay,
because they won't cover this stuff.
Okay, hang on. We're about to go to break. This is Vets doing this.
Yes, Randy. All right, it's Rule of Law Radio. Randy Kelton, Vet Pack. Don't forget it. We've got the phones off. We will be We are back with Rule of Law Radio. Got Randy Kelton, Vet Pack, and Ron Avery. Ron's given us some really good information. Ron, go right ahead and continue.
I'm sorry. Were you talking to me, Yvette?
Go ahead, Ron. Yes, I was. Go ahead and continue. You were telling us, everything that was going on, and you've got a lot of really good information.
Wow, you really broke up really bad there. I didn't hear what you said, but
yeah, just Ron, just speak it up where you dropped off.
Okay. Yes.
We were talking about how the news media can pretty well do anything it wants to and tell any story it wants to. And there's not much we can do.
Yeah, that's we have. There's libel laws, about what libel is, about defamation and things. And I think I want to tell you what I think is the funny stuff on appeal with Hearst Communications Incorporated in the Chronicle and this Dylan Badower, who is the reporter. The funny part about this is that there were about 23 comments made on the blog page or the blog underneath the web articles that they wrote that I sued them for libel. And they, about 40% of the comments, or 9 or 10 of them, of the 23 comments, were all what you would call expressions, written expressions of public disgust and actually hatred, and some of them worse than others. But so this is where, and the statutory definition of defamation is when words are used in a way that exposes a person to public I'm trying to think of the three main words. You think I've been writing them over and over. You'd think I'd remember them now. But it's disgust or humiliation against a person, expose a person to those kind of comments. And so the way they're trying to get away, they're actually saying that their articles are not defamatory at all and don't even have the capacity or the capability to be defamatory, because everything they said in there was talking about our rights to dissent or something like that. And they're saying that they want to supplement the actual evidence of public disgrace and degradation and hatred. They want to substitute a judge to make a ruling that, as a matter of law, those things are not defamatory, what they said about us. So I think that's actually humorous, because is that time coming up for the end? I heard something there. Okay.
No,
anyway,
no, we've got 7 minutes.
Oh, okay, good. Anyway, so they're trying to make the evidence of defamation go away, and the way they're trying to do it is to say, "Oh, those people that wrote that were not reasonable people," and you can dismiss actual evidence, written evidence of defamation, people, the exposure to these kind of comments. You can actually dismiss that by having some judge say, "Oh, these articles are not capable of being defamatory," and well, obviously they're defamatory because the people that read them responded with hatred, wanting to send us to Gitmo and be waterboarded. I mean, when you have actual... and one of the other things I thought was really humorous is that they said, "Oh, these comments that were made at the bottom of the article, the blog, these weren't real people. Those are not real people. Those are anonymous." Well, first they started by just saying, these are anonymous statements that we don't know who they are. They have anonymous icons and code names and, all that. And so they're not real people. Well, that's ridiculous. I mean, because I responded on the same blog, and they had my email. They contacted me after I wrote a response on their blog right under their article. They know these people are real, and so I just think it's totally humorous. I mean, they've run out of gas, really, to making these wild assertions that they even said in their brief that I could have written all those, that I actually had different pseudonyms and went out and different emails, and I wrote all those defamatory statements, or actually wrote the responses to the defamatory statements. So they'll just say anything in order to try to get rid of the evidence. Amazing.
So did they give any evidence that they traced back any of these IP addresses? Or did they just make a bald statement with no supporting facts?
They didn't. No, they just made the statement that it was all what we call hypothetical. They just said, well, it could be, maybe this, maybe that, could be. Well, it's still absurd. Most people don't sit around just making up stuff, and who's got time to just go around and goof up websites and do. And I even responded to that. I said, well, if you want to go with that argument, maybe it's Hearst Communications that's doing this too, to help defame people and change public opinion. Maybe they have a bunch of computers and a bunch of different pseudonyms, and they're writing all this stuff. And I said, that would make them even worse. They're even more liable for defamation and libel if they want to go there. And I said, the best way to deal with this is to reverse this decision, remand it to lower court, And we'll do some discovery and find out. We'll get their emails like you got mine, and we'll go ask them if they're real people. And maybe we can, subpoena some of them and maybe get why they wrote some of those things. So anyway, that's pretty crazy. And so what I'm working on too, I took over a group in Austin here recently. I was asked to take over the A Architects and Engineers. What did they call it? It was something like, I think it was AE 9/11 Action Group. That was the name of the meetup group. And the guy that was the head of it asked me if I'd like to take it over, and so I did. And I changed the name of it to just something a little simpler. It's just 9/11 Truth Austin. And so I'm trying to put together a big thing for the 15-year anniversary of the memorial for the 9/11, event 15 years ago. That's a long time now, 15 years, and we have a lot of information. And this is an ongoing conspiracy, and it is changing form too. We're beginning to see what the further part of the conspiracy is. It's not, the conspiracy didn't just stop after the event of 9/11 and the cover-up, but it continues, and it has a longer-term goals. It has several really goals. And part of it, one of the main goals is to disarm people worldwide, to disarm them and to be able to watch them essentially institute the police state actually throughout the world, so that a global government can take any individual and destroy them, their reputation, and thereby do whatever they want to with them under the false pretense of this terrorism stuff. So,
Ron, we're going to have to take another break. I'm going to pause you for just a second. We'll return in just a few minutes. So this is Randy Kelton, Vet Pack with Rule of Law Radio. We'll be right back.
Great.
It's all according to the will of the Almighty. I read his book and it says he cares not for the unsightly. These warmongers come by that term rightly. I won't pay for the war with my body. Ain't gonna pay for their car with my money. I won't pay for the fun with my body. There's man's wicked and their logic shoddy. Ain't gonna pay for the oil with my body. I won't pay for the boys with my money. Ain't gonna pay for the kids with my body. The whole agenda smells funny. I wanna fight in a war of my own. That one would be less accidental. I wanna pay for a war of my own. They live in glass houses so I can watch them.
We are back. Rule of Law Radio, Randy Kelton, Vet Pack. We have Ron Avery on the line, and he was talking about 9/11. Ron, go ahead and continue.
Okay, thank you, Yvette. I was trying to make the connection between 9/11, the war on terror, the phony war on terror, the cover-up, government cover-up of who really did it, how it was done, all of that, with its continued goal of actually trying to institute a police state, not only in America, but in much of the Western Europe and throughout wherever they can. And it's obvious that the mass media is being used to help accomplish this. And this is where it brings up my lawsuit for libel against the Hearst Communications Incorporated, because even before this Orlando thing happened last year, in 2015, the Chronicle tried to make an alarm, a 9/11 terror alarm, on the weekend of 9/11, and targeted the Republic of Texas, or the people that call themselves the government of the true Republic of Texas, and myself, tried to make us into terrorists to kind of keep the terrorist thing going. And so it just kind of it illustrates the danger of all this phony terrorism that is never investigated by any real law enforcement body, and it's covered up. It's the evidence that is found is covered up, is not reported, making this two different worlds: the world of the people and the internet and the truth, and the world of the government and its mass media, which is fairyland. It's just turned into something that I can't believe hardly anything they say anymore. So, but what I wanted to ultimately get to is that I've taken over this group that's now I call this meetup group 9/11 Truth Austin. We want to put on a big event in Austin for a lot of people, and we want to have a lot of good speakers come and make presentations. I understand that I'd like to have Jesse Ventura come as a speaker. I understand he had a lawsuit that was pretty similar to mine. I haven't looked into it and investigated it yet, but and he won his, I think, $1.7 million, and then an appeals court is trying to overturn that, or they appealed it and try to get it overturned. But anyway, I think that, and it's related to the same kind of subject matter, and I think that would be interesting. I'd like to have Christopher Bolin and have him talk about his book, Solving 9/11. And he's a good friend of mine, and I agree with him that this 9/11 conspiracy is an ongoing thing and has other goals to it. And I've seen it. I've been subject to it, and I think everyone is. This is making everyone into potential terrorists to be slapped around by unlawful government. So I think this is very important. And I wanted to mention, too, there's a place on the internet, Facebook. A guy has a Facebook page, and he has over 15,000 people that are part of it, and they have a little banner. You send in a picture of yourself or an icon, Facebook icon, and he makes a banner for you, and he puts on there 9/11 Truth in whatever country you're from or state. And I think that's really cool. His name is Claudio Marti. He's a great guy, and he said he was going to send me some help from people that are in Texas in his group, and we're going to try to put on a really big show in Austin this coming September 11th on a Sunday. And in fact, we'll be having our first planning meeting tomorrow night or tomorrow evening at 5 o'clock to 6:30 at Brave New Books in Austin. And afterwards, we're going to go someplace and have a bite to eat and have some more social time. But I wanted to encourage anybody and everybody to come out to that and get to know one another and have a blast planning something that will help affect some good change to prevent this abject tyranny from just rolling over everybody and turning this whole thing into a police state that is intolerable to live in. So anyway, really, I think that's about all I had.
Ron, your 9/11 Truth Austin, when does it normally meet and where? So people who are interested can show up.
You know what? I didn't understand a word of that. The way you're speaking, there's something about the way you're speaking. I can't pick it up.
Okay, let me try this again. When does your 9/11 Truth Austin meet?
Oh, it meets. We do not have a standard meeting time of yet or a place. But all I can say is we are meeting tomorrow night, and we'll work out all of that, hopefully, at that time.
Okay, when you get a meeting place and time set up, be sure to let us know so that we can let everybody know where to go and when, so we can actually get something done.
Sure, I'd love to do that. I will do that. And I'd also like to give people my website. It's temporarily down. It's been hacked by somebody, and it's been some stuff put in it that caused a lot of weird things to happen. So I have to take it all down and clean it up. That's what the host said. But when I get that done, hopefully early part of next week, I'd like people to go visit this website to look at this material, because I think they'll find it fascinating about this lawsuit and what this news media is trying to say about what they did and how to get out of it. And it's at postwtc.com. And you'll just scroll down to the bottom there, and it says Avery versus Houston Chronicle. And so it's postwtc.com.
Okay. Then one thing about being hacked. The last couple of times I was hacked, they only were able to get into PHP HTML files on the root directory. So now I've moved. The only thing on my root directory now is index.html. Everything else I've moved to a subdirectory, and I haven't been hacked since.
Well, I don't know. In fact, I'll probably have to consult with my provider to really find out more about it. I don't even know quite how to clean it up, but I have to do that before they let it back on the air.
The provider can show you the string that whoever hacked you loaded into your system. You'll be able to find it. It's generally in the home section, the top section of the page, and it'll be a real strange set of code that you've never seen before.
Okay.
And it'll be the same in every file. I had 2 different ones that I found, and your provider can help you. They can isolate that string and send it to you, and then you know what to look for.
Okay. Thank you.
Some guy in Russia and then some guy in China got me. Okay. Thank you very much, Ron. We're glad to have you on.
Thank you. Thank you, Randy. Appreciate it. And Yvette?
Yes, absolutely. Have a great night.
Okay. Same to you. Good night.
Okay. Now let's see. Hold on just. Okay.
Looks like we might have some callers on the line. Do we want to go ahead and open up phones?
Yes, I have the phone lines open. I'm doing a couple of things here. Okay, we're good. Okay, I'll figure this out in a minute. It's a little too complex for an old guy. Okay, we have a caller on that hasn't been. I'm going to go ahead and take Marv. Shows not to be screened yet, but rather than spend time, I'll check him out. Hello, Marv. What do you have for us today?
Hi. Yeah, well, I just listened to Ron's presentation, and I want to compliment him on him trying to get his position into a courtroom. And I was very encouraged to hear him. I've been watching Ron and listening to Ron for several years, and he's a very articulate, a very astute legal mind. And I've always been disappointed when he throws that Texas Southern Baptist Save Your Soul stuff in with his 9/11 Truth legal. And I was so excited to see that he went through that whole talk of his this evening without doing that. That was very, very encouraging for me. I know we drive a lot of people away with that. I know you guys down in the southern part of the country it's such a part of your culture, but up here in the Northwest, I guess we're secular, and we like to keep it that way. So anyway, it was a very good hour. Thanks very much, Ron. Over.
We are about to take a break. This is Randy Kelton, Vet Pack with Rural Law Radio. Give us a call at 512-646-1984. We'll be right back.
This is the Logos Radio Network.
We are back. This is Rule of Law Radio with Randy Kelton, Vet Pack. And I believe we're about to bring on another caller. Do we have Mark? Is Mark ready, Randy? Tonight's kind of crazy. You guys are going to have to bear with us. Randy doesn't normally play this part. So
Randy forgets to unmute his mic. I think there's a mic gribbling back here. Okay, Mark, what in the heck are you up to today?
Well, Mr. Kelton, I'm attempting to help somebody who actually has criminal charges, and he has been assigned by the judge a public defender because he's otherwise poor-phobic. And the problem becomes, of course, getting your attorney to do things. Now, he's sent off bar grievances, and he's asked the guy nicely, and, not much movement is happening. And I went through the toolbox that I'm aware of things that can be done, and he was given instructions not to file papers in the case, and he was given instructions not to investigate in the case himself, because the attorney got upset when he pulled public records from the police department. And so, given these artificial constraints, the best tool I can come up with for this gentleman is a writ of mandamus to request the judge to order the attorney to do his job. Notably, the attorney filed a motion where he references some over 200 emails and phone calls that the victim has been doing to the alleged victim has been doing to the person charged with the crime. And he never entered them in as evidence at all in the case. And there's enough weirdness in these phone calls and emails that I would think it's important to get it into evidence, and the only way I can see this guy doing it at this stage is a writ of mandamus. Is there another tool that we should be looking at?
I'm thinking how to get your attorney to do his job. Does this guy have enough? Do you know an attorney who might audit this attorney's work?
No, but that is a aspect that has not been mentioned, and whether or not there could be an audit of the gentleman's work. I've told him to look over this guy's paperwork in other cases to see what he's done in the past. He's also only been an attorney for a year.
Ooh, and you've already grieved him?
Oh, he's already been bar grieved. Apparently, our fine state of Wisconsin, the bar grievance procedure, they now stack them all together as one grievance per case. So
okay.
It's no longer two.
Okay, hang on. Grievances. I got something for you. I have to dig it out of my archives, but I researched out and found all of the insurance carriers.
Okay.
For legal malpractice.
About 13 of them in Wisconsin, that based on the research I've done.
I did underwriters.
Yep.
So
that's where I
got a bunch of those. Right. But when I did my looking, I found something else. I'm trying to re-find it. It was when you have to notice your insurance carrier that you have a potential claim. Oh, this is good. Let me find it here. It listed, I went down this thing and it's listing all of these things that the lawyer has to give notice of. Lawyer insurance notice requirements. I think somewhere I have a link to it if I can. It's hard for me to talk and think at the same time. And people listening to me already know that. Okay, you're required to give notice under your insurance policy if you have a professional liability problem. Everyone knows that, or almost everyone, as there are still reported cases where lawyers have spent years dealing with claims before notifying their insurers. What many lawyers do not realize is that these notice provisions also say who has to get notice, how the notice has to be given, and who has to give notice. A few recent cases show that failure to strictly follow these instructions could cause lawyers to lose the insurance coverage they paid for and relied upon. Okay. Who has to get notice and what do they have to get? Most insurance policies require that the insurance company itself receive notice in writing of a claim or potential claim. Many times the policy will actually include the address where the notice has to be sent. Of course, it's probably the best to make sure that the company is still at the address of the policy. What lawyers think is that they can call their insurance brokers about a problem, and this is all the notice they need to give. In some cases, that might be enough. Okay, this is not the part I want to get you. Take the case of the Boys versus Continental Gas, where the court found there was not coverage when the lawyer failed to timely report a claim in writing to the insurer directly. During the policy, the lawyer received 2 letters indicating a client's intent to sue the lawyer. Over a year later, the client filed suit against the lawyer. The lawyer defaulted, and judgment was entered for about $200,000. The client sued the insurer directly. This is not the one I was looking for. See if I can find it. Anyway, this is. I'll find the other one, but it's saying that if you have any reason to believe that you might potentially suffer a claim, you have to give notice.
Okay.
So I was reading that. I'm reading that thinking, we need to develop some emails that very specifically point to a claim. If you fail to file this motion in my behalf, you will harm me by failing to adequately represent me. The way I read this notice provisions, that would be enough.
Okay.
And certainly if you notice them that if you don't do this, I will sue you for malpractice. That one he absolutely has to get.
All right.
But
I will.
More directly, what I'm thinking is give send your own lawyer a tort letter. Has this guy's lawyer tried to get himself removed from the case yet?
He has made the threatening noise of, well, you want me to remove me from the case? And he's went to this guy and said, you're adversarial, and trying to, structure and get a rise out of him so that he could try to approach the judge with that. And I've already given him the song and dance and seltzer down your pants that you have pointed out. Judge, you're interfering with this third-party contract. The contract, I'm the third-party beneficiary of, and I'll sue you directly. So he's already gotten that.
The judge told him he was adversarial?
No. The attorney has made the noise of it, but he's never filed any paperwork. What it seems to be is the young attorney hung on his shingle, didn't get enough business, and is now a contract worker as a public defender. And he's otherwise going with the golden rule of, if I file nothing and there's nothing in the case, it's very hard to have any appealable errors. And so he's otherwise sat on his hands and done very little to make sure that there's no appealable errors. And he filed 2 motions, but hasn't scheduled a motion date, and it's, now coming on half a month where motions were filed and nobody seems to have scheduled a motion date.
Yeah. Okay, we're about to go to break, but when we come back, let's talk about a tort letter to his own lawyer.
All right.
All right, Randy, are you ready to go out for break?
I am ready.
All right. This is Rule of Law Radio. You're listening to Randy Kelton, Vet Pack. We've got Mark on the line. We'll be right back. Call us at 512-646-1984.
Sticks and stones may break my bones, but names will never hurt me. Whoever came up with that was sure wrong. I'm Dr. Catherine Albrecht, and I'll be back in a moment to explain how your first, middle, and last names can actually affect your immortality.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This public service announcement is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
The initials of your name could significantly impact how long you live. According to a University of California study, positive initials like VIP or ACE could add more than 4 years to a man's life. Negative initials like PIG or DIE could shorten a man's life by 2 years. While women are less impacted by negative initials than men, positive initials can add 3 years to their lives. Researchers believe initials are powerful symbols that affect how people are treated and how they feel about themselves, and research supports it. Those with negative initials were more likely to commit suicide and die in accidents than those with positive initials. So name your kids well. I'm Dr. Catherine Albrecht. More news and information at CatherineAlbrecht.com.
Trails.
Looking for some truth? You found it. LogosRadioNetwork.com.
We are back with Rule of Law Radio. You're listening to Randy Kelton, Vet Pack, and we have Mark still on the line. Mark, go right ahead. We kind of cut you off for our break. Mark, are you there?
Hold on. Okay, I got him. I didn't unmute him.
Randy was going to discuss the tort letter. The only real concern I have on the tort letter is ultimately the threat of I'm going to sue you for a guy with no money and, not really up to snuff to handle a case himself. I'm thinking it'll be taken as a rather toothless threat. It isn't like me threatening, hey, I'm going to sue you, or, you walking in.
I guarantee you it'll terrify him. Because more than that, what it will do is turn the politics to your side. The judge appointed the lawyer to this case. And think in terms of a four-sided chessboard. The client is sitting on one side. To his right is his counsel. To his left is opposing counsel. And across from him is the judge. The client has a relationship with his counsel. His counsel has a relationship with opposing counsel and a relationship with the judge, especially if he's court-appointed. And he knows his job is to make sure that his client does not have grounds for appeal.
Yep.
That's his main job. So what your client needs to tell him is your only purpose in this trial court is to set the record for appeal. I need you to get the facts and the law on the record. If you fail to get any pertinent fact or any relevant law on the record, I will sue you for that failure. And if you attempt to get removed from this case, I'll sue you for that. This is your job. You got paid. Do your job. I'll do my best to put you out of business. What you don't say is now go run to the judge and ask the judge to save him from the no good, rotten, unruly client. It's exactly how I got my last case in Austin dismissed when the DPS knocked out one of my teeth. The lawyer who kept telling me that I'm going to get him disbarred. And I kept assuring him I didn't care. I told him from the start that, he's telling me how things are going to go. And I said, no. That's not how they're going to go. Well, then, Mr. Kessler, just how are they going to go? This is how they're going to go. You're going to go to the judge and ask the judge to remove you from this case. And I'm going to go to the judge and tell the judge, don't you dare remove him from this case. He's my attorney of choice, and he's under contract. Well, I'm not under contract to you, Mr. Kelton. I'm under contract with the state. Yes, you are, but I'm the intended third-party beneficiary. And if you remove this lawyer from the case, I'll sue you for tampering with the contract. And I know you've already heard that. But he needs to tell this to the lawyer and make sure the lawyer understands it. And especially, he needs to make sure the judge understands that he's unruly. Because you got to know, judge is going to rule against him out of hand at every turn. He's not going to find justice in a criminal court, especially with court-appointed counsel, unless he gets that counsel to go to the judge and say, you got to save me from this client. They dismissed my case to protect my lawyer from me.
Well, and I've told him that, and I've said, look, and I told him 3 years ago to start listening to, go back through the We the People archives, go through the archives of your show, and listen, and, get up to speed on things, and, because your stories are consistent on that, and I've given him the same rap, and he's busy writing down things like, I will say to him multiple times over the course of multiple months, you need to do this, and I can hear him writing it down, and then he never does it. So I can only work so hard to try and help him, but I thought that the writ of mandamus asking the judge to order him to do certain things was an interesting attempt at creating politics.
And I think that would be excellent.
And
because it gets on the record that your attorney is not doing his job.
Mm-hmm. Yes. And he explicitly was told, don't do more things in this case. Well, a writ of mandamus is an entirely new case. Each writ is his own new case.
Well, okay, who told him not to do anything in this case?
Oh, his attorney. Because I told him, I said, your attorney's going to sit on your hands and do nothing. I said, the police reports are a public record. And in fact, there was a interesting interaction between the alleged victim and the police after the case where she self-admitted in a phone call of the inculcate crime of trying to get him busted for contacting her through a third party. Well, it turns out that she was utterly wrong, and there was nothing there. But that record, he went down to the police department and paid the 25 cents and had a copy of the record pulled and handed it to the attorney. And the attorney was just livid. I don't think it was because you talking to the victim can create a real problem for you in a criminal case. You contacting the victim in any way, shape, or form can really be a problem. That's Class G, Class I, Class H felonies, depending on how you do it. But I think it was just this gentleman having the, temerity.
It's a cool word. Termitity. The unmitigated gall.
That's right. Do something in his own case. And again, as you stated, the attorney's job is to make sure there are no appealable errors, and the easiest way to have no appealable errors is nothing in the record and do nothing.
I have a question. What if you went down and requested this information under the Open Records Act?
Oh, I certainly could, but now I'm taking 2 hours of my time to drive there, and wait shooting.
No, do it by mail.
Do it by mail. Okay.
Yeah, better they never see you.
Yeah.
Now they got a third party sharpshooting them.
Yeah.
Now they're wondering, who is this ringer?
Oh, once they put my name into the thing and start asking lawyers in this county, they'll suddenly know who the hell I am. The Supreme Court knows who I am. And actually, if you go into the court records and you search for my name, I show up as a third party, unrelated, in the criminal case, filing paperwork. They're letting me put in paperwork in criminal cases where I'm not anybody. So I'm developing a reputation.
Good. They need to know that this is exactly why I do this show.
You're going to love, once I get the stuff all structured and everything, you're going to love what I pull with the Supreme Court and trying to get them to make me a lawyer on paper. I got a little something planned, and once I get all the ducks in a row, I'll let you know on that one, because that'll be a hoot.
Well, in some states, you don't have to go to law school. Tennessee.
Correct.
All you have to do is pass the bar.
Right. Wisconsin is one where they want you to have went to law school somewhere or be a practicing lawyer somewhere. And I'm going to take an angle of, I demand that right of privacy in my communications, and the only way to do that is to be a lawyer. So give me that bar card.
That is interesting. Okay.
Yeah.
Hang on.
We are going to have to take a break. This is Rule of Law Radio with Randy Kelton, Vet Pack. Call us at 512-646-1984. We'll be right back.
Well, karma's lurking around the corner. You better watch every step you take. And good will follow you. Yeah, Billy Jerry, sing reality.
This is Rule of Law Radio. We are back with Randy Kelton, Vet Pack, and we are talking with Mark. You guys go right ahead. Continue.
All right. So what would give me the ability to bring that up is the state of Wisconsin Constitution. Anything that was the common law, anything that was the common law, and the legislature has not legislated, is up for grabs. And the privacy issue under common law, well, it's sort of up for grabs. And then we've got that judge who said immigration law is understandable by a 3 or 4 year old. And so maybe this being a lawyer doesn't need magical anything if a 3 or 4 year old can understand the law, eh?
That's pretty simple.
It's a wonderful set of arguments I've been working up.
So that is an interesting approach.
Yeah.
To claim your right to privacy.
Yeah. Well,
I need to look at that.
The lawyers have otherwise worked very hard to say, my God, we've got to make sure that our right to have private communications defended. And the Supreme Court has otherwise went with, oh, yeah, that's important. Okay. Make me a lawyer. You got the power.
So you already have these rights. If they're under common law, then you would have the right anyway, unless it's been specifically taken away.
As far as I can tell, it hasn't.
I want to take some thinking. Okay, you should have this right without regard to counsel or not counsel.
Yeah, but the only way the right is protected is with the magic bar card. And that's what I'm seeking, is the magic protection. And there is law out there that when a law is otherwise ignored or a condition is ignored, you end up with that ignored state being the actual law. And I've got to develop the case law on that.
Okay, I've got one, if I can re-find it, that says that practice can develop the appearance of law, but it never takes on the force of law. Hall v. State.
Okay.
And it's a state case.
All right.
I don't remember which one, but it addresses just that issue. Practice is not law. And if you're saying that in Wisconsin, the common law prior to the statutory law is unaffected unless it is specifically addressed by statute. And that's really the way it is in Texas as well.
Yeah, Michigan is not. So one state over, the common law is dead. But that's why Wisconsin had to go ahead and explicitly make a marriage law with a one-man, one-woman thing, because there were parties going, we're common law married, and that's why they got rid of common law marriage in the state of Wisconsin. It's also illegal it's a felony to be an adulterer in the state of Wisconsin. And if you have a dance, you're supposed to have a county dance supervisor. But lots of fun here.
What? Adultery's a felony in Wisconsin?
Yep. Still on the books.
Whoa. That would take some really big jails.
Yeah, it would. It's one of those laws, kind of like perjury in the courtroom. It just isn't conveniently enforced.
Well, what is the remedy when a public official fails to perform a duty he's required to perform?
You taking it exactly the way they're giving it to you?
Yeah, this has been the tact I've been trying to take and get other people to take. I just filed criminal charges against a federal judge in Fort Worth. I went to the court building and asked ask for access to a federal judge in his capacity as a magistrate. And I was sent to the clerk. And the clerk accepted my document where a criminal complaint affidavit where I wrote on the top of it for presentation to some federal judge in his capacity as a magistrate. And the clerk took it, stamped it, and took it in. 2 weeks later, he sent it back to me with instructions that I needed to take this to a U.S. attorney. And while I was talking to him, he told me I needed to take it to a U.S. attorney. And I said, where's that in law? I can't find that anywhere.
Right.
Everything I find in law directs a complaint to some magistrate. So I gave this to the clerk, and the clerk took it in lieu of the magistrate because he wouldn't allow access to the magistrate. But he took it in for the purpose of giving it to a magistrate, and he didn't. So what crime is that? I call it tampering with a government document.
Well, and
that's
in Wisconsin. Well, and here in Wisconsin, we have 96801. 968 is the statute about how a criminal complaint is created. 96801, Section 2. The complaint is a written statement of the essential facts constituting the offense charged. A person may make a complaint on information and belief, except as provided the complaint shall be made upon oath before a DA or judge, as provided in this chapter. So I've had no end of fun walking in with my plutonium in the form of a written complaint and asking a judge to witness it. Oh my, it's like I'm the plague, and it's, you know, they scatter. And I talked with a disbarred judge about this when I was having a meeting about a person who felt that they were being electronically stalked. And the judge, ex-judge, he blinked a few times, and we had a 15-minute conversation about this particular aspect, and he said they will not take that. They fear it. And that's been the reaction I've gotten. And the question, as you've stated, well, what law is being violated here? And at some point, I'm going to be springing that on some judge in Wisconsin and going down the tar baby route of, I got this tar baby here. Want to touch it?
Exactly. Well, in mine, I'm going to take a complaint and prepare a complaint against the clerk and send it certified return receipt to the head federal judge for the Northern District. And I will charge the clerk with secreting the complaint from some magistrate. And I suspect I'll get a nice, friendly letter from this judge giving me sage advice, telling me how I need to take this to the U.S. attorney. And then I'll go to the U.S. attorney with criminal charges against the judge.
Exactly.
Man, don't get upset at me, guys. I didn't write the law. I just read it.
That's right. And the law is supposed to be understandable by a 6th to 8th grade education. So, and the law is rather clearly written here. So, you know, sign this.
What?
But I've got paper.
What?
I got paper from a judge saying, no, we're not going to even take this sheet of paper. So,
Mr. Bailiff, I need you to arrest this judge.
Well, the last time I had an issue with the bailiff, the judge bailed me out. The judge came out of her chamber, not in robes and everything, and calmed the situation down once she heard my name.
Well, we need to just, you know, they're the servants, we're the masters, and we need to act like it. If we can get more people doing this, we'll have less problems with these judges.
Well, Masonic Lodge, the way in which that's run is the lodge is run by the members. The person who's the master of the lodge, yeah, he's all powerful. He's got the gavel. But ultimately, it's the lodge's lodge. And the master of the lodge is just there at the good graces of the people, the other members of the lodge. And that's exactly the framing that you've given in the past of, this is my courtroom, my laws. You're just the all-powerful person sitting there who's got the gavel, and when you wrap that gavel, you're magic.
Yeah. I'm the master, you're the servant, and I very generously allow you to administer the law in this courtroom. I do not allow you to have a personal opinion. I don't allow you to have an attitude. You will determine the facts in accordance with the rules of evidence and apply the law as it comes to you to the facts in the case. If you have another agenda, you need to get down off that bench. I don't allow my judges to administer justice. Problem with that is every judge will have a different concept of what is just.
Correct.
My judges are to administer the law consistently. If the law does not create justice, then we go to the legislature to correct the law. We don't allow our judges to decide which law should be applied and which one should not. And that's my story, and I'm sticking to it, even if I run off the cliff at the break.
All right.
You're not going to run off the cliff because I'm going to save you. This is Rule of Law Radio. You're listening to Randy Kelton, Vet Pack. Call us at 512-646-1984, and we'll be right back.